say is also a massive welcome to Jason, who's part of our team, as I'm sure you're aware. So we're doing this talk this morning, our normal monthly breakfast at Broadway, but it's a bit of a twist this month, because of course Jason's going to deal with the Uber case that he was successful in. So sorry for it to be a spoiler alert there, but I'm sure you all know already. In the second half of this morning's breakfast at Broadway. What I'm going to do is I'm going to deal with three cases that came up this month fairly briefly, because obviously I know you want to hear from Jason, but it'll just give you a flavour of, for those of people who haven't joined us before, of what happens at these breakfast at Broadways. It's effectively an update of the last month's cases, just to keep us all current. And if there are any questions, what we tend to do is that you can use the chat function for any questions, and use the chat function. We've got other members of the team here, and they'll answer questions as they go along as I'm talking. And if there's any other questions at the end, we can try and clear those up at the end. So use the chat function for questions. We find that works best. Also, what we're going to do moving forward, we've had a powwow about this, and we normally, before pre-lockdown, in the olden days, before we had to do everything virtually, we would hold these in our chambers in Leeds. What we've decided is, because they're so popular, is that we're going to do a hybrid moving forward and have them virtually and in person. So if people want to come for a free breakfast in Leeds, they can, and have a chinwag in Leeds before and afterwards. But if you want to join and watch it via virtual means, we're going to keep going with Zoom and have it virtually as well, so you can sit in your gym jams and watch it virtually as well if you want to do that. So that's the plan moving forward. Hopefully you'll carry on joining us. So let me just start the PowerPoint so that you can see where I'm going today using this wonderful technology. Hopefully you can all see that. Can you all see that?
Yeah, all fine.
Excellent. So obviously what I'm going to be, there's the three cases I mentioned I'm going to be talking about today are Allais and Galen, which came out this month. The motherhood plan, I'll call that. It's a bit of a mouthful, against Her Majesty's Treasury, which deals with some pandemic guidance effectively. And Levi and 34 & Co Limited, which was a small case that came out, but it raised some interesting questions. So, Allais and Galen. So this was a reasonable steps defence case, which I thought was an interesting case this month, and something which may interest everybody here. Obviously, in terms of reasonable steps defence, this involves racial harassment, and an employer can defend a claim resulting from otherwise unlawful discriminatory actions by an employee by relying on section 109(4) of the Equality Act, if it can demonstrate, and this is the acid test, that all reasonable steps were taken to prevent the employee from either committing a particular discriminatory act or committing discriminatory acts in general. So that's the test. Have they taken all reasonable steps? So the facts in this case, the perpetrator of the harassment and 3 other employees who were aware of it, including 2 managers, failed to report it to HR. They had all received equality and diversity training around 2 years earlier. So this happened in 2017, and around 2015, they had received the equality and diversity training from the employer. The claimant, who was of Indian origin, commenced employment on the 3rd of October 2016, so sometime after the training had been delivered to these employees. After his dismissal on the 15th of September in 2017 for performance-related reasons, he complained that he'd been subject to harassment relating to race by a fellow employee who we'll call P. There was an investigation, and it was established that P had in fact made racist comments, and he was therefore required by the employer to undertake further equality and diversity training. Following on from that, the claimant brought claims for harassment in the Employment Tribunal. And of course, the employer relied on the reasonable steps defence. They said, we had provided equality and diversity training, we did an investigation, we found the comments had been made, and we then provided more equality and diversity training to ensure that the employee was aware of their obligations. The tribunal, however, rejected the reasonable steps defence, and they upheld the complaints of harassment. It accepted that the employees had all received training that covered harassment relating to race, but they noted that it had been delivered 2 years earlier, and what they found was that this training was clearly stale. And so therefore it found that the respondent hadn't taken all reasonable steps to avoid discrimination, and what the tribunal said was that a reasonable step would have been to provide refresher training in equality and diversity. And the need to provide such training was amply demonstrated by the remarks made by P, the perpetrator of the discriminatory words and treatment, and the failure of the 3 colleagues to properly react, i.e. report it to HR. The respondent appealed, and you can probably understand why the respondent appealed, because they had provided the training and they thought that they were onto a good thing in terms of the reasonable steps defence. But the EAT actually rejected the appeal, and effectively what the respondent said is that the effectiveness of the equality and diversity training is irrelevant. It's the fact that they had given the training and therefore they had taken all reasonable steps. And the EAT rejected the argument that effectiveness of the training is irrelevant to the question of what is a reasonable step, or whether they've taken all reasonable steps. And in considering the reasonableness of the steps an employer has taken, it's not sufficient to merely ask whether there has been training. What was said in the Allais and Galen case is that consideration has to be given to the nature of the training and the extent to which it was likely to have been effective. And as to the question of whether there were other reasonable steps that should have been taken, the likelihood of such steps being effective will always be a factor in determining whether such further steps are reasonable. So effectively, because the test is have they taken all reasonable steps, the tribunal effectively have to consider whether there were further steps, and looking at whether or not they'd be reasonable, the tribunal should look at the effectiveness of the training that's been provided. The tribunal clearly concluded that the training the employees had received was stale. So what the tribunal said, what the EAT said, was that that was a proper conclusion for the tribunal to reach, that the training was stale, and the conclusion was not based merely on the fact that the perpetrator, had made racist comments. They had actually looked at the effectiveness of the training overall and taken into account the managers who hadn't reported the racist remarks, and therefore it was no longer effective, and the AT found that the tribunal were entitled to come to that conclusion. And in fact, the tribunal took into account the fact that the perpetrator, P, thought that the remarks he was making were no more than banter. And effectively what the tribunal said was that was further evidence, or the EAT agreed, that was further evidence that the training had faded from P's memory, because he didn't understand the nature of banter and how that could be discriminatory. They found that the tribunal were also entitled to conclude that the fact that managers didn't know what to do when they observed harassment, when it was reported to them, also suggested that that training had faded from their memories. And there was nothing to suggest that further training of a good standard wouldn't have been effective, because what effectively the respondent was saying was that, well, if we provided further training, it wouldn't have been any more effective because we'd provided training already, and these employees hadn't learned from the training that we had provided. Now, one important factor, I think, is that this fact that the respondent had provided the perpetrator with further refresher training, effectively that was a double-edged sword for the respondent. They had some difficulty with that, because what the EAT said was that the fact that they provided the perpetrator with further training after the event meant that the respondent must have thought that it was likely to be effective. So it's a bit of a circular argument. But on the facts, effectively, what the EAT said was that the tribunal was entitled to find that the training was stale. In terms of this case, looking at the discussion from on the slide, it's a salient lesson to employers to keep their equality training up to date. And a period of 2 years was deemed to be sufficient to show that the training was stale. So when advising employers, what I would suggest is just ensure that their training is kept up to date, particularly when they're faced with a situation, particularly if they're a large employer. And it may be that you want to start advising employers following this case that annual refresher training doesn't have to be, full formal training, but annual refresher training would be a good idea to avoid them getting into this situation if they have to use the reasonable steps defence. The 2-year period was also coupled with the fact that the managers did nothing when they became aware of the discriminatory acts. And again, that's something which you should advise, that the managers should be reporting these matters, whether or not they believe in it, whether they believe it happened. It's the reporting structure which seemed to be important in this case, and ensuring that employers know that their employees should report, including their managers, should report these matters to HR if they have an HR department, or up the chain if they receive such complaints, or they're aware of such language being used. I mean, effectively, there has to be some sympathy with the employer in this case, as they appear to have been punished for trying to put things right following their investigation, because they did an investigation, they found that race discrimination by way of harassment had occurred, and provided further training. So that's what led to the rather circular argument that by providing further training, they acknowledged that the existing training wasn't effective, and therefore they hadn't taken all reasonable steps. So if you're faced with this, it would be quite brave, but it may be that you would advise, well, don't provide any further training, because if you do, you're acknowledging that your training wasn't effective in the first place. So this rather begs the question of what an employer should do in these circumstances. And in fact, what I would suggest, it would have probably been safer for the employer to have interviewed the employees in question, ascertained whether they understood the previous training given. If it was recorded that they had understood the previous training, then the argument could have been run that providing further training wouldn't have made any difference to the discriminatory behaviour, and therefore they had in fact taken all reasonable steps. But save for that, the employer was of course in a difficult position in this case. The next case I'm going to deal with is the motherhood plan case. So this is close to the heart of many barristers, because we're all self-employed and all earn under £50,000 a year. So we're able to use the self-employment income support scheme. And that's what this involved, the self-employment income support scheme. And it was a challenge to that scheme by one individual and the Motherhood Plan, who are a charity who campaigns for the rights of pregnant women and mothers. And it was an application for judicial review. So it's not something which we would normally deal with as employment lawyers, but it's clearly an important case in terms of the self-employment income support scheme, which was put in place by Rishi Sunak in around March of last year. And effectively, the facts of the case was that it was the claim for judicial review was brought on the basis that the scheme itself was indirectly discriminatory, and that the Treasury had acted in breach of its equality duty, public sector equality duty, and that was effectively the challenge. And what they said was it was said by the claimants that it was indirect discrimination because it applied the PCP that applied to everybody, i.e. providing 3 years worth of accounts, and the payment being based on the last 3 years worth of accounts was applied the same to everybody, but then it disadvantaged women who had been on maternity leave in the relevant 3-year period, and it wasn't objectively justified. And you can see the basis of that argument, because of course if a woman has been off with maternity and pregnancy, she will have earned less in that 3-year period, and therefore the calculation would have been lower for that woman who had been on maternity leave, because her earnings would have been lower in that 3-year period. They also argued that it's still an indirect discrimination argument, but they argued that using Thlimenis and Greece, which is the 2001 case, effectively that different cases should be treated differently because women who were on maternity leave are in a unique situation, and that therefore their payment should have been calculated differently to avoid indirect discrimination. It's still an indirect discrimination argument, but on a slightly different footing, and also the public sector equality duty under section 149 of the Equality Act. And effectively what happened in this case is that it was the judicial review application to the High Court, and it's quite a long judgment actually, and there was a lot of consideration of the papers and the directives between the Treasury and Rishi Sunak at the time, and effectively the case was rejected, and it was found that it wasn't indirectly discriminatory. What effectively the High Court said, well, firstly they observed that the pandemic had led to far-reaching social restrictions and a dramatic reduction in the turnover for many businesses, and that the scheme, the SICE scheme, Self-Employment Income Support Scheme, had been devised under enormous pressure and had to be devised quickly. And it was aimed with getting payments out to the self-employed as soon as possible. And what the High Court said was that the quantum of payments under the scheme had to be based on some proxy, and the decision that it would be an average of the last 3 years' trading profits was a reasonable proxy to use when deciding how to base the payments to be made quickly in order to support self-employed individuals who were having to enter lockdown and therefore couldn't trade. And what the court said, that there wasn't any indirect discrimination on a conventional analysis. And what effectively it found is that the disadvantage to women who had been off on maternity leave or pregnant was not caused by the scheme itself. What they said was that the disadvantage flowed from the absence of or a reduction of a person's income in the past. So it wasn't the scheme itself that was discriminatory, it was because the person in the past hadn't had as much income due to maternity and pregnancy, and therefore that was why the disadvantage arose. And the reasons, the High Court said, for those past lower earnings were not relevant given the context and the purpose of the scheme. So they looked at the purpose of the scheme, they looked at the context of how it was developed, and effectively found that the reduction or the lower payments for women who had been on maternity leave or had been pregnant and unable to work in that 3-year period were not relevant. They dealt with also, effectively what the court said was that if they were wrong on the, and you can see there are arguments for indirect discrimination, and it's quite understandable why this claim was brought, because on the face of it, it does look like women who were pregnancy or on maternity leave would have been disadvantaged by the scheme. But what the court said was, even if they were wrong on the indirect discrimination claim, clearly any disadvantage or any discrimination was objectively justified because of the nature of the scheme, and because effectively the Treasury had to have some proxy in order to be able to work out how much people were being paid. And the objective justification used by the Treasury was the purpose of the SICE, the purpose of the scheme itself, policy delivery, mitigation of fraud. And you remember that was something that was in the press about wanting to prevent fraudulent claims in these matters, the avoidance of perverse effects, and also, interestingly, the minimisation of cost, because what the Treasury was saying was that if we had to look at every case individually, we'd have had to have a much wider IT system, and our IT system couldn't cope with that, so we just had to base it quickly on the last 3 years' earnings for everybody. So everybody, it was applied the same to everybody based on the last 3 years' earnings. And what the court found was that those matters were objectively justified any discrimination if they were wrong, and there was discrimination caused by reason of the scheme. In terms of the public sector equality duty, what they found was that it had been that the difference in treatment had been considered, and effectively it is only the fact that if the duty itself, all that has to happen is that a public authority has to have due regard to the need to eliminate discrimination. And after looking through the briefings, I think there were 7 briefings in total, after looking through them, it was clear that they had been given due regard to. And in fact, hard cases, and you remember in the press, hard cases have been referred to in respect of these schemes. They found that there were some hard cases, but they found that this was the fairest way that they could administer such a scheme. So because due regard had been given to the need to eliminate discrimination, then the equality duty, had not been breached. So that was, as I say, an interesting case in relation to indirect discrimination. It's a long, there's a handout that you'll all get at the end. Leah will put it in the chat, or I don't know if she already has done, but there is a handout, and there's a greater analysis of the case in there. If you're interested, you may not be. You may all just be bored and waiting for Jason, who's the main event today in terms of the Uber case, but hey ho. Finally, Levi 34 and Co Limited. Now, this was a claim for unlawful deductions, and I know they're not always the most lucrative claims, an unlawful deductions claim, but this was a grave and weighty case where the claimant brought a claim for unlawful deductions for £148.62. So a very important case in the scheme of things. This followed his employment of just under a month. And that was important because at the time, an employee who was employed for a month or more, was entitled to written particulars of their employment. Well, effectively, they're entitled to written particulars, but at the time when this case was decided, if they were employed for more than a month, then it didn't apply. For less than a month, I beg your pardon, then it didn't apply. And effectively, the case was about a Section 38 uplift for a week's pay. So they were arguing that about £1,150 should have been paid rather than the £148.62, which was the actual deduction, because there should have been a mandatory 4 weeks' pay award made for the reason for the failure to provide the written particulars. And effectively, what this case said was that what happened in this case, and again, there's a more in-depth analysis in my handout. But what effectively happened was that the respondent didn't bother attending in the employment tribunal because it was for 148 quid. They weren't interested, so they just said, if you want to award £148, do so. So they didn't. They put in a response, but didn't attend at the tribunal. The tribunal judge then effectively heard the case in the absence of the respondent, found there'd been an unlawful deduction of £148. What had happened is shortly before the final the hearing, the representative had put in a schedule of loss, including the uplift, but the respondent had no notice of that because they didn't take part in the proceedings. The tribunal judge didn't make the uplift, so the claimant appealed, wanting the uplift for 4 weeks' pay. Now, what had happened is the tribunal judge had actually got it wrong in terms of the length of time the claimant was employed, because the tribunal judge had been told he'd been employed from the 29th of October to the 28th of November and found that was a month, which arguably it is, even though it's a day short. What in fact had happened is the claimant had resigned without notice on the 27th of November, so hadn't been employed by a month. So what effectively happened in the EAT in this case is the EAT judge said, well, in any event, if the judge had known everything, the judge wouldn't have awarded the uplift anyway. There was an argument about whether further evidence could be adduced. The judge fudged that and said, well, I'm going to use proportionality in this case and allow that evidence in this particular case, because he already knew, the judge in this case already knew that the claimant hadn't been employed for more than a month. And therefore, in those circumstances, the appeal was rejected because effectively but there is an interesting discussion on there. And as I say, if you look at the handout, you'll see the discussion about whether further evidence should be allowed into the EAT and the practice direction number 9 in exercising discretion to admit fresh evidence in the AAT following Ladd and Marshall and those cases of that ilk. There's an interesting discussion for a claim worth £148, 62 pence. There's quite a lot of discussion about those elements. That's why I raised that one. I thought it was an interesting case. And as I say, have a look at the handout. You can see a bit more about that grave and weighty case. Right, we're just on about 8:30. I'll stop sharing my screen. And I'm now going to hand over to Jason, who is going to talk to you about the Uber case. Thank you, Jason.
Excellent. Good morning, everyone. And thank you very much for inviting me to participate in the Broadway Breakfast at Broadway seminar. Matthew, I think I can trump your weighty case because as you were speaking, I was reminded that the seminal case of Delaney and Staples, do you remember that one? That looked at whether a non-payment can amount to an unlawful deduction for the purposes of the same statutory provisions. And I quickly looked it up while you were speaking, and the sum involved in that case was £137.50. So it goes to show, doesn't it? Small amounts of money, but very important cases nonetheless. So yeah, an important one to talk about. As you will probably now know, the Supreme Court gave its judgment in the Uber case on Friday, the 19th of February. It had been some 6 months since we'd argued the case in the previous July, and many commentators had wondered whether the delay in producing a judgment was because the Supreme Court was struggling with its decision, didn't know whether perhaps all the justices were agreed. Many thought there might be a split decision. It was a court of 7, incidentally, because Uber were inviting the Supreme Court to depart from the earlier decision in the case of AutoCleanse. So there was much debate about whether it might be a split decision. But as we now know, it was a unanimous decision of the Supreme Court, only 6 justices giving their judgment, or in fact 5 agreeing with Lord Leggatt, because Lord Kitchener was indisposed. We understand he was unwell, and that was probably the explanation for why the delay. What we've ended up with actually is a fantastically clear, well-written and very powerful judgment for Lord Leggatt that in my view will set the tone for any argument about employment status going forward. As you know, there have been countless cases leading up to AutoCleanse, Pimlico Plumbers, AutoCleanse, Bates, Van Winklehoff. In my view, pretty much all of those can go on the shelf now, and the only case you now need to look at is the Uber decision. Let's just begin by setting the scene. What was the main issue in the Uber case? As you, I'm sure, know, that to be an employee, you have to work under a contract of employment, and to be a worker, you have to either work under a contract of employment or any other contract whereby you undertake to do personally some work or services for the other party to the contract who is not a client or customer of a business carried on by you. So the essential provisions, you've got to undertake to work personally for the other party to the contract. And it won't have escaped your notice that the word contract comes up regularly there. So to be an employee or a worker, you've got to have a contract. Well said, Uber, we've got contracts with our drivers, and we've also got contracts with our passengers. And those contracts make it very clear that drivers are not working for us. They are in fact working directly for passengers, and we're merely their agent. We handle the booking on their behalf, but essentially what we're doing is connecting drivers with passengers, and the essential business relationship is as between driver and passenger. There's a tripart arrangement, and even if AutoCleanse were right, and it was appropriate to look to see whether the true agreement was reflected in the documents, set it aside in the case of Sham, you can't do that with a commercial agreement. And our agreement with passengers for the use of the app is a pure commercial arrangement. And in fact, the arrangement between drivers and passengers themselves is a commercial arrangement. So you've got to start with the contracts. And if the contracts correctly set out the arrangement between the parties, AutoCleanse gives you no authority for looking behind it. So that was the essential question the Supreme Court had to grapple with. And if you've followed some of the press coverage since the Supreme Court gave its judgment on the 19th, you may have seen that Uber have said, well, the judgment only really applies to the 25 people that were party to that litigation. We don't think it applies to the 50,000 Uber drivers that there are working around the UK. It's very fact specific. And in fact, I was talking to a solicitor just yesterday who hadn't read the decision, knew that I was in it and said, oh, it just turns on its facts, doesn't it? No greater import than that. Could not be further from the truth. And the reason why I think Uber is absolutely wrong to say that the judgment only applies to the 25 or so that were party to the litigation. In reality, Uber lost on every single argument they put forward, every point that I argued, and confession time, they even lost on a point that I hadn't put forward. So what did they lose on? There are three strands to the judgment. The first, probably only of particular relevance to the Uber case or for minicab drivers generally. I'll mention it briefly because it's an important part of the judgment. So the first ground on which they lost was Lord Leggett said the documentation doesn't create the relationship of agency that Uber says it does. So even if they're right to say, just look at the documents don't get them home. That's because the documents don't specifically appoint Uber to act as the driver's agent. So there's no express appointment. Uber then said, well, you can infer it from conduct. And Lord Leggett said there wasn't sufficient evidence adduced before the Employment Tribunal to show that drivers had appointed Uber to act as their agent, even based on conduct. Okay, so straightforward black letter argument, you're relying on agency, and I'm not satisfied either expressly or by inference have drivers appointed Uber to act as their agent. And you may well say, well, that's easy to correct, isn't it? That's perhaps Uber's easiest get out, because all they need to do now is get all of their drivers to sign up to a document that expressly appoints them as their agent, and they could say, well, the judgment no longer applies. Lord Leggett went on to say, actually, I'm going to deal with all of the other arguments as well. So they lose on the primary black letter argument, but let's turn and look at the others as well. The AutoCleanse argument, Uber say AutoCleanse goes too far. It does not give tribunals the power to disregard contracts. They've got to start with the contract, and if the answer is found in the contract, you go no further. No, said Lord Leggett, tribunals are not engaged in an exercise of contractual interpretation. They are engaged in an exercise of statutory interpretation. There's an extraordinary passage in the judgment, actually, it's paragraph 85. I know Paul's just put a link up on it and you might want to have a look at it. But for those of us that studied law and contract in particular, brought up in the sort of black letter tradition, just think about the consequences of what Lord Leggett has to say at paragraph 85. There is no legal presumption that a contractual document contains the whole of the parties' agreement, and no absolute rule that the terms set out in a contractual document represent the parties' true agreement just because an individual has signed it. That's pretty breathtaking, isn't it? No legal presumption that a contractual document contains the parties' whole agreement, and no absolute rule that even if you've signed a document, it sets out your agreement. In fact, what Lord Leggett had to say was, you don't really start with the contract at all. I mean, the contract is, although he says it's not completely irrelevant and shouldn't be ignored, we know you have to have a contract because the statute requires it, but actually it serves no other purpose than as a gateway to get you through the door. And actually what the tribunal is looking to determine is the nature of the relationship. Is this the sort of relationship that Parliament intended ought to fall within the ambit of the statutory protection, in that case, particularly minimum wage or working time? And how do you determine whether this is the sort of relationship that Parliament intended fall within the ambit of the statutory protection? Well, the touchstone of an employment relationship, said Lord Leggett, is the degree of subordination or dependence there is as between the putative employer and the putative employee, echoing EU law. So EU law uses very similar terminology. It doesn't use the words subordination and dependency, but it talks about the hierarchical nature of the employment relationship. So different language, but it means the same thing effectively. So wherever you've got that degree of subordination and dependency between putative employer and putative employee, you are likely to be looking at an employment relationship. The correlative of the other side of the coin of that degree of subordination and dependency, said Lord Leggett, is the degree of control that is exercised by a putative employer over a putative employee. So those are the three words you need to take away from this judgment when you're looking to see whether someone is in an employment relationship. Is there subordination or dependency as evidenced by control being exercised by the putative employer over the putative employee? And that is now effectively the test to determine whether someone is in an employment relationship or not. And we can come back, and please do ask questions in the chat function to look at the broader application, I think, of that test. So not only is auto-cleanse still good law, but in my view, the Supreme Court has pushed the boundary still further. It's extended auto-cleanse and made it even easier for individuals to claim that they are either an employee or a worker. One of the interesting questions, in fact, I say employee or worker, one of the interesting questions that has arisen is the extent to which this judgment will be used when people are seeking to show that they are employees in the narrow sense, not just that they're workers. Obviously, the issue in this case was whether drivers are workers. None of them were seeking to establish that they were employees. But as you'll probably know, the test for deciding whether someone was either an employee or a worker had pretty much morphed into one. You might remember Lord Justice Underhill has said in a couple of cases, Windle most recently, that the test for determining whether someone is employed under a contract of employment or a working contract are essentially the same, just with the boundary pushed further in favour of the putative worker, or there's a lower pass mark in deciding whether someone is a worker rather than an employee. But the tests are essentially the same. We still need mutuality of obligation, that degree of control, personal service, etc. So if that's right, I'm pretty clear that this judgment in Uber is just as applicable if you're looking to decide whether someone is an employee as whether they are a worker. So that was the second strand, the auto-cleanse strand, what you might call the purposive interpretation of the statutory provisions. Who did Parliament intend it should fall within the scope of the legislation? The answer to that is not to be found in the contract, but is to be found in an analysis of the relationship, looking at subordination, dependency, and control. Fantastically powerful. What about the third strand? The third strand that Uber lost on, and this is a novel one, and this is the one that I didn't argue, so I can't really take credit for, but Lord Leggett did ask me about during the course of the hearing, and I encouraged him in this direction. I take a little bit of the credit. You're probably all aware that in most of the statutory provisions that we're looking at here, minimum wage, working time, particularly under the Employment Rights Act, there is a prohibition on contracting out of statutory protection. So the prohibition that were most common, that we find most commonly, section 203 of the Employment Rights Act, for example, any provision in an agreement, whether a contract of employment or not, is void insofar as it purports to exclude or limit the operation of any provision of this Act. That's why we have to enter into settlement agreements when we try to settle cases. So you cannot contract out. And we've usually thought of those as being the sort of provisions that expressly contract out. You agree that you will not sue me for unfair dismissal. You agree that you will not sue me for unlawful deductions of wages or for discrimination. So that kind of express provision, contracting out, we know is prohibited by the statutes. Well said, Lord Leggett. I think those contracting out provisions apply not just to an express contracting out provision, but anything in a written document that directly or indirectly has the effect of preventing someone from enforcing their statutory rights. And the way in which Uber have drafted their contracts has the effect of preventing these drivers from enforcing their statutory rights. So I would be prepared to say that any provisions in Uber's written documentation that prevent drivers from enforcing their statutory rights are void. So either the statutory provisions are a sham in the auto-cleanse sense, but even if they're not a sham, they're void because they infringe the prohibition against contracting out. And again, that is an extraordinary finding if you think about it. How often are we, when advising employers, asked to draft contracts in a way that ensures that an individual does not fall within the ambit of the statutory protection? Now Lord Leggett's saying it doesn't matter what you draft, because if I can see that there is sufficient subordination, independency and control, then anything you've put in that contract is void, because it's prohibited by the it's contrary to the prohibition on contracting out. And I think that makes it fantastically difficult now for anyone to advise an employer on the terms that ought to go into a contract to avoid a finding of worker status. If you go all the way back to where Uber started, it was conceded in the employment tribunal that Uber would have been able to construct a business model that meant it didn't employ drivers. It hadn't got it right with the documentation it had produced, but it would have been able to set itself up in a way that meant its drivers were not its workers. And if you think about it, that ought to be true. If I decide to set up a business and provide certain services, I ought to have the ability to decide whether I want to employ people in order to provide those services, or whether I want to engage with genuine independent contractors in order to provide that service. It's my business model. Well, Lord Leggett comes close to saying, actually, the choice is out of your hands. It's not quite that black and white, because of course what he's really saying is, if you genuinely want to engage independent contractors, then stop trying to control them. Stop exercising the degree of control that Uber does in relation to its drivers. So stop telling them to drive Toyota Priuses, because don't they always turn up in a Toyota Prius? Stop telling them they've got to smile at their customers and be polite. Stop having a rating system whereby you get the rating that the passenger gives on the drivers and you exercise what is in effect disciplinary control over them through the rating system. So effectively a warning process if they get low ratings and deactivating them from the system if their ratings drop below a certain level. If you want that amount of control, then effectively you have to employ them, workers or employees. If you want to work with genuine independent contractors, then if the car's dirty and it's not a Toyota Prius, then there's nothing you can do about that. So that's really what Lord Leggett is saying here. If you've got that control, then it doesn't matter what the contract says. So that's why I think not only is it a fantastically powerful judgment, but Uber is completely wrong to say, well, we just need to tinker with our terms and conditions and this judgment will no longer apply. Because they've lost really, not only on the what your terms and conditions say argument, but they've lost on sham, they've also lost on the restrictions on contracting out. So what have we learned over and above that? Here's a really interesting thing. On the same day, the Uber judgment came out, Friday the 19th of February, and I don't know if many of you saw it, perhaps slightly overshadowed by the Uber judgment coming out, but Matthew Taylor had written a piece in The Guardian, or certainly he was quoted in The Guardian. Does anyone remember Matthew Taylor and the Good Work report some years ago now, produced with great fanfare? Matthew Taylor was the person that effectively headed up the inquiry that was conducted into, in particular, gig economy working, and made a number of findings and recommendations that at the time the government said they accepted wholeheartedly. They went out to consultation with a view to introducing an employment bill that was going to implement the changes as recommended by Matthew Taylor. The consultation came to an end in 2018 and the government's done virtually nothing. And that was the import of the article on Friday the 19th. So Matthew Taylor had been appointed by the government as, I forget his exact title, he was known as the Labour Standards Enforcement Czar. He was the Director of Labour Enforcement, and his term of office has very recently come to an end, and he's not been replaced. So that position is vacant. And according to the article, Matthew Taylor had even volunteered to carry on in the role unpaid in order to see that his recommendations were carried through to law, and the government turned him down, said he couldn't even do the job unpaid. And there is at the moment no sight of an employment bill, maybe late 2021, maybe early 2022. But the government is not doing very much to implement the Taylor recommendations. Why am I telling you all of this? Because the big recommendation made in the Taylor review is that law and employment status needed to change. The test needed to be simplified, and actually what tribunals needed to focus on was the degree of control exercised by putative employers over putative employees. That really was the touchstone of an employment relationship, said Matthew Taylor. I went back and I looked it up. For those of you that don't believe me, page 36 of the Taylor Review, and you'll see he talks about specifically the need to identify control. So I think what we've ended up with is the government dragging its heels on implementing the Taylor Review, but the Supreme Court has done the job for them. So in this judgment, the Supreme Court's effectively said the touchstone of an employment relationship, subordination, dependency and control, effectively what Matthew Taylor said the test should be back when they produced their Good Work report. And I know many of you will think it's not the function of the Supreme Court, it's not the function of judges to make law. And I think that will be an interesting debate on the extent to which the judges have gone too far in effectively dictating what the test should be for worker status and implementing the test that Taylor argued for. So I think that's why, again, why this is such an important judgment. I'm just going to make a couple more short points, and I'm going to stop and give 10 minutes so we've got time for questions, which I'm happy to take. What happens next? What happens next? So 25 Uber drivers. We know there are some 50,000 around the country, but it's not just Uber drivers that are affected by this. There are lots of other industries where this judgment will apply. But Uber has specifically said it only applies to the 25. The case for those 25, of course, now has to go back to the Employment Tribunal. All that's been decided at the moment is that they're workers and therefore able to bring their claims for national minimum wage, for paid holidays, etc. And one of my clients has got a whistleblowing claim. So those claims will now have to go back to be determined by the tribunal on their merits. Uber have already said it's not going to cost us very much money because we're not going to implement that in relation to any of the other drivers. And I think there's an interesting trend here as to how respondents in a lot of these status cases are responding to judgments. Because effectively Uber are ignoring the judgment of the Supreme Court. Okay, they're certainly ignoring the spirit of it and saying it doesn't apply generally. And I've seen that happen in other cases. I also acted for the claimant Mags Dewhurst in a case called City Sprint. You might not have heard about it because it was determined at first instance in favour of my client, who was a cycle courier. City Sprint then appealed to the Employment Appeal Tribunal, but a couple of weeks before the EAT was due to hear the case, they withdrew the appeal. They withdrew the appeal because they said, we've rewritten our terms and conditions. We've effectively changed the bits in it that the Employment Tribunal found against us on. And now we don't think that the judgment has any real relevance because all of our cycle couriers are working under these new terms and the judgment of the Employment Tribunal says nothing about the new terms. We're just going to ignore it and we're going to carry on as we have been because we've made those amendments to our terms and conditions. And this is anecdotal, so I don't know whether this is true or not. If anyone does, you can tell me. But I had a Pimlico plumber round at my house last year because I had a problem with my central heating. The Pimlico plumber came round, and of course, in the Pimlico plumber's case, the Supreme Court found that Pimlico plumbers are workers rather than genuine independent contractors, in particular because they had no right or no genuine right to substitute someone else to perform work or services on their behalf. They could only use another Pimlico plumber. But when that case was remitted to the Employment Tribunal, again, just like Uber, the Supreme Court just decided the status issue. When it was remitted to the Employment Tribunal, the individual, Mr. Smith, lost because he'd presented his claim out of time. When the Pimlico plumber was round at my house, I said, oh, you must be very pleased you're getting paid holiday now. What he said, we're not getting paid holiday. But didn't that case in the Supreme Court decide you're entitled to paid holiday? No, he said, Charlie Mullins told us all that Mr. Smith had lost his case. We got £100 Christmas bonuses and that was it. Nothing else has changed. Anecdotal, I don't know whether it's true or not. But if it is true, City Sprint, Pimlico plumbers and now Uber, respondents essentially saying, we're just going to ignore the judgment. We're going to tinker with our terms and conditions and say that that judgment doesn't apply to us. And I think that's a very worrying trend if that's the way that things are going. It might be different now because on the back of Uber, I know that there are a number of firms gearing up to bring class actions. And a couple of firms out there, I think, have already signed up thousands of minicab drivers. So I'll leave you with this thought, the sting in the tail of platform working. So Uber relied on the fact that they were effectively a platform, merely introducing drivers to passengers, not themselves providing services. And they said this is just indicative of the way in which the world is evolving and the use of technology. It doesn't make us an employer. Well, someone's used social media against them because one of the firms I understand has signed up something in the order of 11,000 Uber drivers now, by, you guessed it, advertising on social media as a result of the decision of the Supreme Court. So we hope that certainly in relation to Uber, it's not going to be enough for them to say it only affects 25 drivers. Thousands of drivers are now going to bring claims. And I'm pretty clear that having lost on all 3 points, not just any one in particular, they'll lose again if they attempt to resist these claims. So there you go. Sorry, I've run slightly over time, 7 minutes left. That's a summary of what's happened in Uber and why I think it's such an important case. And I'm more than happy to answer any questions that people have got about that.
Thank you,
Matthew,
Jason.
back over to you.
Questions on the chat. Let me just go through those. So the first one is making it less attractive to enforce statutory rights the same as preventing them from doing so? Does that make it indirect prevention?
So, I mean, if you read the judgment, the answer to that is probably yes. And yes, I think for two reasons. One, the tenor of Lord Legate's judgment is anything, whether directly or indirectly, that prevents and an interference with or something that inhibits people from bringing claims. I think it falls within the scope of his judgment. But it absolutely is consistent with the approach of EU law, isn't it? So anything in EU law, the jurisprudence is very much anything that inhibits you from doing something is tantamount to preventing you from doing it. In relation to paid holiday, for example, the rationale for all of the EU judgments on why you're entitled to the full amount of your pay, not just holiday pay calculated on the basis of basic, but it has to be basic plus bonus, is if we only gave you holiday pay calculated on the basis of your basic pay and not bonus, that would be a disincentive for you taking your holiday. And therefore that would not be consistent with the EU, with the UK honouring rights to paid holiday. So it's consistent very much with the EU approach to this, which is anything that inhibits you from doing something is tantamount to a bar. So yeah, that's certainly the way that Lord Legate, I think, intends it. I've just seen while you're on there, someone's mentioned IR35 yes. and HMRC. Really good point about HMRC, first of all. I've mentioned the fact that there are class actions now gearing up to bring claims against Uber, but another way in which the judgment might end up being enforced is via HMRC. And there are two possible routes for this. One is the VAT route. And again, a delicious sense of irony about this, because Uber relied on the VAT cases all the way through EAT, Court of Appeal and Supreme Court to say, look, in the VAT field, it's commonly accepted that drivers can be the provider of services, and therefore it's the driver that charges VAT if they're above the VAT threshold that Matthew was telling us about right at the beginning. We are not the provider of services. Lord Legate didn't find any of those cases helpful at all. Fantastic example of dismissing a whole line of case law just in a throwaway. I did not find that of any assistance. But if it's right that Uber is the employer of the driver, it is also the provider of the services, which Lord Legate said he thought also followed from the regulatory regime, then Uber should have been charging VAT. It hasn't been charging VAT, and HMRC might come to it for what some people have said might be a £2 billion VAT bill. And in current circumstances, if that's a possibility, you'd think that absolutely HMRC might pursue them for it. So that's one way in which you might get sort of large scale enforcement of this. The other, of course, is in relation to the tax situation. HMRC might look again at the question of whether drivers were employed rather than just workers. They might do that. They're not being encouraged to do so by drivers who are quite happy to be self-employed but workers. But that might come under the spotlight. I won't say very much about IR35. You can do a whole nother topic on IR35. But essentially, I think the Uber test will now apply when employers are having to make assessments of whether someone is their employee under the IR35 regime. I'm pretty clear they ought to be looking at this test for those purposes.
Thank you, Jason. Then the other question that just a bit further up the chat, what impact does it have on the medical sector where locum GPs and pharmacists, etc., there's always a need for some control due to the nature of the roles? It's a good question.
It is a good question. I've advised on a couple of these cases. And to make the question slightly wider, not just medical cases, but of course, there are lots of independent contractors working, not just the vulnerable individuals that are very much the focus of the Uber judgment, but they're very, very professional individuals, for example, medical or otherwise, working on a self-employed basis. Does the judgment apply to them? I mean, the test certainly does apply. And in all of these cases, they're going to be fact specific. And I think one of the problems of this area of the law, I'm not sure there's an answer to it, is that the cases are always going to be fact specific to some degree. And when you've got very professional people, there'll be some control over working conditions, but less control over how they actually carry out the work. For example, often the case with surgeons, you don't tell a surgeon how to do the job, but you might have control over where they work from, for example, and the times that they work. And those, I think, every case will turn on its particular fact. But linked to that, someone's put up, what about personal service arguments? And there is a link here with those medical cases. Importantly, and I think this is a crucial distinction, personal service was not an issue in Uber because minicab drivers have to be licensed. Certainly there's a licensing regime in London. So the drivers themselves have to be licensed and there's no possibility of sending a substitute. If you order an Uber, you get a picture of the driver, you get the registration number of the car, and only that person can turn up to pick you up. The statute, of course, requires, yes, that you work pursuant to a contract, but it's got to be a contract under which you agree to perform work or services personally. And the classic case on this, Ready Mix Concrete, Mr. Justice McKenna, is the one that talks about the requirement of personal service. Freedom to do work by one's own hands or by another's is inconsistent with an employment relationship. So I do think the one area that Uber doesn't touch is the issue of personal service. And that I'm going to argue that point next Tuesday and Wednesday. So I'm in the EAT on Tuesday and Wednesday next week on one case where personal service is the key issue, and Uber is being cited to say the landscape has changed effectively. This is now the new test. But I'm for the respondent in that case. And one of the arguments that will be run, so please look out for the decision when it comes out, is Uber doesn't really apply where the issue is personal service. You've still got to have personal service for there to be an employment relationship. And I just think of that in the context of doctors, for example, who inevitably will have to provide personal service.
Thank you, Jason. Well, that's just about 9 o'clock. Fantastic timing. Thank you, everybody, for coming. Thank you to Jason. Thank you to those who have contributed to the chat. Great to see familiar faces and new faces to joining us today.